presided over both jury trials in this case. As a judge, I do not know what happened in Yellow River Park. I was not there. The attorneys were not there. The families were not there. And oftentimes in jury trials, you have the state's version of events, the defendant's version of events, and oftentimes the absolute and unequivocal truth lies somewhere in between those two versions. I acknowledge that 2 mistrials after 2 jury trials does not provide any closure for the Lang family. But honestly, I don't know what could possibly provide closure to the family under any circumstance. And I recognize that. I can't sentence Mr. Ford for the offenses for which he was not convicted by 2 juries. But I am authorized to sentence him for the 3 offenses for which he was convicted. With that being said, I impose sentence as follows. I'm going to start with count 8, concealing the death of another. For that offense, I impose a sentence of 10 years to serve in confinement. He'll be entitled to credit for time previously served on these charges as he is lawfully entitled to and as determined by the custodian. On count 7, theft by taking of the motor vehicle, I impose a sentence of 10 years probation consecutive to count 8. On count 6, theft by taking of the firearm, I impose a sentence of 10 years probation concurrent, which makes the aggregate sentence on all 3 counts a total of 20 years, the first 10 years to serve in confinement. I impose the following conditions: a $1,500 fine plus any court costs and surcharges, the monthly probation reporting fee, the indigent defense application fee for the services of court-appointed counsel. I order that while he is on probation, he is not permitted to consume any alcohol or drugs unless they are lawfully prescribed to him. He will be subject to random screens and must waive specimen admissibility in any court proceeding for any positive screen results. I order that he undergo an alcohol and drug evaluation and that he complete any recommended treatment. While on probation, he is not to have any contact of any kind, directly or indirectly, with any member of the victim's family, their residence, their place of employment, or any school location. The defense has asked that I treat Mr. Ford as a first offender. It is undisputed from both sides that he has no prior criminal history and he appears otherwise eligible for that treatment. However, taking into account everything that I am lawfully entitled to consider, I decline to sentence him as a first offender. I also order that the state present to me today a null pros order on the preceding indictment in case 22B 03732-3. I also note for the record that the indictment in which issue was joined for the second trial was provided to Ms. Banks Brown at the conclusion of the hearing, and that indictment will need to be filed with this court's sentencing order. I believe I also need to address, even though I have entered an order on the mistrial for counts 1 through 5, this sentencing order will reflect a mistrial for counts 1, 2, 3, 4, and 5 on the sentencing order.
On the last one, Judge?
On
1, 2, 4, 5.
I'm sorry, thank you. Counts 1, 2, 4, and 5. Count 3, voluntary manslaughter, was a directed verdict. And the Senate sheet should reflect that. Let me advise Mr. Ford of some appellate rights, and then I'll turn to each side to determine if they take issue or need any clarification on the court's sentence. Mr. Ford, if you feel that your rights were violated, you may challenge your conviction in one of two ways. First, you have a right to directly appeal from your plea by filing a notice of appeal within 30 days of the date that your sentence is filed. Second, you can challenge this proceeding through a habeas corpus petition. That must be filed within 4 years for felony offenses, and all of your convictions are in fact felonies. And that 4 years runs from the date that your sentence is filed. Mr. Ford, do you understand these rights? To further clarify on your right to appeal, you do have a right to seek post-judgment relief from your conviction of the crimes by either making a motion for new trial in this court and or by filing an appeal to a higher appellate court. If you want to file a motion for new trial or an appeal, then you will need to file the appeal. You will need to file the motion or a notice of appeal with the Clerk of Superior Court of this county within 30 days. You can discuss that more fully with your attorney, Mr. Lewis. If a motion for new trial is in fact filed, and after a hearing I deny that motion for new trial, then you will have 30 days from the filing of the order denying your new trial in which to file with the clerk of a court your notice to appeal to a higher court. You have the right to have an attorney represent you on your motion for new trial and the first level of direct appellate review. If for any reason you cannot afford to hire an attorney, the court will provide you an attorney and one copy of the transcript of your trial at no cost. Mr. Lawrence Lewis, I'll ask that you file the initial motion for new trial within 30 days, and if you are requesting to come off of the case for appellate purposes, if you will indicate that, and I will appoint Mr. Ford different appellate counsel if he wishes to appeal.
I'll handle that, Judge, in 30 days, within the week that you filed in the sentencing order.
All right, let me turn now first to the state for any questions or clarification needed on the court sentence.
No, Your Honor.
Mr. Lawrence Lewis.
Judge, respectfully,
I don't know the credit for time served date. I don't know if the prosecutor's making a suggestion. I do know that March 29, 2022 was the interview with the lead detective, and I do know at some point in time my client made his way to the Gwinnett County Jail. I suspect that at some time between the time that the detective spoke to him and the time he arrived at 2900 University Parkway, warrants were filed against them and holds were placed, but I don't know that date. So I don't know if the court is going to try to figure out, or if we should figure out what that credit for time served date is now, or if you just leave it to the calculation of the custodian, and then if I disagree with that, I'll file a motion to amend the credit for time served date. I don't know how you want to handle that. I just don't know what his credit for time served date is, Judge. And obviously I would ask that he receive credit for time that he served. The date back to March 29th would give him 16 months. I think at the date when he arrived would probably be closer to 14, so I'm not quite sure what date the warrants dropped and the hold was placed on him when he was in Clayton County.
All right, and I typically stay out of that dispute. It is within the purview of the custodian to determine what credit he is lawfully entitled to receive. For that very reason, I do not put a specific date. I leave that up to the custodian. That is within their purview to determine the appropriate credit. Any other issues with the sentence as announced from the defense?
no, thank you, Judge.
All right, Mr. Ford, do you understand your sentence?
Yes.
All right, I'll also instruct the state to maintain possession of the evidence, to file an evidence and retention log with the court at the earliest convenience.
Yes, sir.
All right, then that is going to conclude the sentencing hearing. Mr. Ford is remanded to the custody of the sheriff.